that the nature of the hearings are so very different as well, that somebody might walk into a family courtroom one day and just go, what in the world's going on here? This doesn't look anything like what I saw on TV. I would love for all of my general jurisdiction colleagues to have an opportunity at some point to hear dependency cases, because in the dependency arena, you really do boil down what the best interest of the child actually means. You could have a party arguing, my child's not safe in this house because the refrigerator isn't working right now. Where the counterpart on the other side is, the child's not safe in the house because there's never been a refrigerator in the first place, and there's jagged things around that the kid can bump into, and there's stuff all over the.
We are here with District Court Judge David Gibson on a perspectives video on the topic of dependency proceedings. Why don't you let us know a little bit about yourself and what kind of cases you see in your department?
All right, Alex. I have been on the bench as a district court judge now. This is my third year. Prior to that, I served as the hearing master in the district court, family district court, hearing juvenile dependency cases for about 6 years. So then I was appointed by Governor Brian Sandoval, finished out the previous judge's term for 2 years, and then luckily ran unopposed this time around. And now I have my first 6-year term in front of me. Prior to that, I was a general practitioner, had my own practice for most of the years that I was practicing, and my practice covered about 50% family law, and then the other half was split evenly between criminal and civil litigation. So I came from a general practice background, and had picked up a contract doing dependency work as a defense attorney for several years, and then when the hearing master position opened up, I had applied for that and gotten it. So I've been in the dependency realm now for about between being an attorney, a hearing master, and a judge, about going pushing 15, 16 years. It seems like a long time at this point. And then my current calendar, when I took over Department L, I had a general domestic calendar. But given my background in dependency, there was a feeling that at some point I would make a shift over as we were gearing up to have nothing but district court judges hear dependency matters instead of district court judges and hearing masters. And then last year, as the pandemic struck and things started getting rearranged in the court systems, Chief Judge Bell thought it would be prudent to not only have me start taking dependency matters at that point in time, because it seemed like a natural transition point, but I also, half of my calendar is now juvenile delinquency as well, so juvenile crimes. So from day to day, I alternate between child protective cases and juvenile crime cases.
We get a lot of questions on juvenile delinquency. We might have to do another one of those someday in the future. I guess the first question here will be, to what extent should the judiciary engage with and educate the public? A lot of our viewers were pretty surprised to see that you were putting quite a few posts on your Facebook page, and I think that's something that should be encouraged. But yeah, I'd like to get your opinion on that first before we start.
Yeah, I had always intended to use that public figure page to communicate major developments, changes in calendars, different things like that, so that the public in interacting with either the county website or that Facebook opportunity could know what it was that Department L was involved in. I personally feel like a judge should and really has a duty to interact with the public as transparently as prudent, as frequently as possible. There's a lot of, I've noticed over the years, there's a lot of misconception about what a judge's job might be, time in the courtroom versus time out of the courtroom, different things like that. And I think that the more you educate the public on what it is that you're doing, I think it creates a greater comfort level with the general public so that they feel like they have more access to justice. That's really our goal. We are a full branch of the government, and we are accountable to the people. We should be interacting with the people as much as we can within the constraints of our judicial ethical canons.
Really heartening to hear you say that. And you're not the only one. There's a Court of Appeals judge from Georgia who's done a few podcasts on the use of social media to engage with and educate the public. And I know Chief Justice Jim Hardesty mentioned it at the State of the Judiciary address that the judiciary has to do more to engage that. So I guess we'll go ahead and go into the questions now. The first one is evidentiary hearings. They're starting to pop up in some of our non-family division cases as well. We covered a Petrocelli hearing before District Court Judge Jerry Weiss recently. What is the difference between an evidentiary hearing and any other type of hearing?
Okay. Well, at its most basic term, an evidentiary hearing is a hearing where evidence is actually taken. So you'll have witnesses who are sworn in and testifying under oath. You will have the rules of evidence governing documents or other things that the court views and then ultimately makes a decision upon. So whenever you need to swear someone in, that hearing is, I think by definition, evidentiary in nature, because you would be taking evidence and then deriving your decisions from the evidence that you receive.
You'd be surprised. A lot of the general public just assumes the court takes evidence at every single hearing. And so this is a constant distinction we like to make to sort of educate the public on the fact that not every single hearing is evidence is not necessarily involved at every single hearing. So I appreciate you making that distinction for them.
Yeah, I think you'd find that the vast majority of hearings are not evidentiary in nature. When you come up watching TV, watching court on TV, it's just it's the specific hearings where the judge is pronouncing some kind of a sentence or anything like that. And that's the perception of what goes on in court. Mm-hmm. If you've watched, Perry Mason or Matlock, or I'm dating myself now, but or any of the new, the newer courtroom dramas and things, you get the idea that the courtroom is like a fast-paced environment full of argument and reveals and things like that. But really, it's kind of boring. If you watch court proceedings, there's a lot of quiet time, downtime while lawyers are getting their questions or their arguments together, while judges are thinking about what they've heard and making a ruling on different things. And so, the general public's perception, I think, unless they've had the opportunity to really observe court, is going to have a different point of view. The other thing too is there are so many varieties of jurisdictions that different officers, presiding officers, whether they're hearing masters all the way up to judges, are hearing, that the nature of the hearings are so very different as well, that somebody might walk into a family courtroom one day and just go, what in the world's going on here? This doesn't look anything like what I saw on TV.
It's true. It's why I try to provide those little informational tidbits, which they do seem to appreciate. I was kind of surprised how many people actually liked watching jury instructions. I was thinking that would be especially boring, and I ended up getting a tremendous amount of feedback saying that they actually liked it. So I guess maybe we have a different audience or a different approach or something, but the people are watching that stuff. So the next question will be, certain family court proceedings are open to the public. Which hearings does the law appear to allow public access to?
Okay, well, specifically in the dependency arena, most of the hearings are presumed to be open to the public. The big question is, how's this going to affect the child? And what's that child's best interest? And is that particular hearing being open to the public going to somehow impact the child in a way that would be hurtful or stigmatizing or something along that line? Is really the measure of it. Now, in dependency, what you'll find is the hearings that are typically closed are those that are evidentiary in nature, adjudicatory in nature. The specific ones that are outlined by statute are that early preliminary protective hearing and then the adjudicatory hearing that would follow. From then on, from disposition and your review hearings, those are presumed to be public unless there's a good reason not to be. And then following that, at the ultimate end of it, if there is an adoption proceeding or a termination of parental rights proceeding, those are also typically closed to the public. I think the reason is at those hearings, the evidence has not necessarily been established yet, and the nature of the allegations that are tied to dependency hearings when you're dealing with abuse and neglect are very sensitive, have the potential to really impact someone's life, especially if they're wrongly accused. And so those hearings are the ones that I think the statute says, okay, we need to take a step back here And now the statute does allow for those hearings to be opened up if there is a sufficient outweighing public interest as well. It's just, you're dealing with presumption of closed versus presumption of open.
Right.
In other family court cases, like in our juvenile delinquency cases, as far as press coverage goes, we typically have an open courtroom policy as long as the camera's not trained on the child, and the child's name isn't being used. We tend to allow the press and cameras into those proceedings because the public does have a strong interest in the public protection aspect of juvenile delinquency, because you're talking about kids. Though it's described as delinquent behavior, it really is, it's criminal behavior is described by statute. And so the public does have an interest. Now, you don't, obviously, as you would in any criminal case, you don't want a zoo or a circus going on in a courtroom. You've got to be able to maintain order, and you want people that are there to have a legitimate reason to be there. But at the same time, as opposed to our dependency statutes, which specifically say certain hearings aren't open, we don't have a counterpart to that really in the delinquency side. It's more of a of an open type of proceeding. Then with regular family domestic proceedings, they are again presumed to be open but they're very easy to close and easy to seal. The way that the legislature has dealt with that, with the statutes that apply, frankly, I think legislators might have put themselves in the shoes of parties and realized, if I'm getting divorced, somebody could see everything about my finances, about my relationship with my spouse. So I'm going to make it easy to close that hearing. And so those hearings are a lot easier to close. Those ones, basically a straight request that it be sealed will typically result in it being sealed and closed.
I wholeheartedly agree. And there's actually, I don't want to mention the name because I don't remember it and I don't want to butcher it, but there's a Washington, D.C. based group that said the same thing generally, that legislators appear to have put themselves into the shoes of the actual litigants. And anyway, that could be its own video. It's such an important topic, and I don't want to sideline us. So we're going to go pretty thoroughly into the process now. And I guess the most important question is, how does your department first become involved in one of these types of cases?
Okay, there's two ways that the district court becomes involved in one of these cases. The first way is if we have considered and signed a warrant for the removal of a child based on an application from the Department of Family Services. There was a case out of Reno a few years back now that went to the Ninth Circuit, and the Ninth Circuit ruled that if you're going to interfere with someone's right to their child in that kind of a way, to take them out of their home, that absent exigent circumstances, you need to get a warrant. So we have a warrant process set up in dependency court. It's on a rotation between the 6 judges that hear it, and we cover each other for it, but we're basically on call, on a rotating basis, 24 hours to potentially review situations where the department has a question of whether or not a warrant's needed. In most circumstances, in the exigent circumstance, and that's a legal term of art, what it basically means is an emergency. You're going to lose key evidence, or someone's going to be hurt or something if you don't intervene right away. And in those circumstances, the department is empowered by statute to go ahead and remove the child. And in their parlance, it's present or impending danger. If there is something going on that they can see actively happening that threatens the safety of the child, they're empowered to intervene and to pull the child out. However, there's a lot of circumstances where it might be on the bubble. You might have a lot of information about the parent is frequently involved in certain activities that could jeopardize the child. The parent is frequently impaired, and there might be periods of time where a vulnerable child is not receiving at least a minimum level of safety in their home. But when they get out there to investigate it, they don't see it actually happening, and they don't have key indicators that this child might be in an imminent risk of harm. And in those circumstances, they will first staff it with their own supervisors. They have their own attorneys. The district attorney's office represents the department and the state in these matters. And so they do have people that they can consult with as to whether a warrant would be required. If they determine yes, a warrant is required, they will prepare an affidavit. They'll submit it to our warrant program. The judge who's on call will review that, has the ability to call the worker and swear them in if they need to for further information. And then the judge will make the judgment call as to whether a removal should happen at that point in time. But the vast majority of removals really should only be exigent circumstances. The department receives a lot of funding up front to work with families with the goal of not disrupting a child's life so greatly as a removal. So if they can safely work with a family up front, theoretically, it should never even come inside a courtroom. They should be able to handle the vast majority of the cases that get called into their hotline informally. But that's one of the ways that a court gets involved, is by signing a warrant. The other way is if they make the determination that a removal is required and they don't think they need to seek a warrant for it, then the statute requires it within 72 hours. And because of the civil procedure rules, that's been determined to be 3 judicial days. So within 72 hours, they have to bring it in front of a judge with competent jurisdiction to review all the measures that the department took and to determine whether or not reasonable efforts were made to prevent that removal, and then to either accept the removal as having been legal and trigger some further proceedings, or to make a decision at that point that if it was not contrary to the welfare of that child to remain in the home, or if reasonable efforts were not made to prevent the removal, the court is directed by statute to order the immediate release of the child to the parent. So those are the 2 ways that we come in. It's either on a warrant review or that preliminary protective hearing is the first time we're seeing anything. And that's triggered by the filing of a report with the clerk's office, which then gets its date scheduled.
It's impressive. I actually had no idea that there were that many safeguards in place with the removal process. And I think you probably just dispelled like 3 or 4 different myths floating around there. So I'm sure the viewers will appreciate that detail. The next question goes into the preliminary protective hearing. Could you tell us a little more about this type of hearing?
Yeah, the ultimate findings that need to be made at a preliminary protective hearing is the court needs to make an inquiry and make sure, to the degree that they can with certainty, define who the parents are, find out who's on birth certificates, who may be putative as a father, somebody they know they're the dad, but they haven't formalized the rights, that kind of thing. Determine who the father and mother are. Our cases do track by the mother's name, because even in cases where you have multiple fathers, at least you've got the one guaranteed parent that you're dealing with, the mother. So you determine who the parents are, whether the birth certificates are legally in order or not, if there are any current or existing custody orders between the parents that govern contact with the child. We also have to determine whether or not the child is of Native American ancestry. So pursuant to a federal law called ICWA, ICWA, the Indian Child Welfare Act, we do have to make a finding at that hearing, and we have to follow that up all the way through, that the child is not a member of or eligible for enrollment in a signatory tribe, because if so, the tribe does have has jurisdiction that can supersede the courts, and they can intervene and take the case completely away from us. So we need to make sure there's no competing jurisdictions that have a greater claim on the child. For that reason, we also try to establish what the child's domicile for the previous 6 months has been. Very frequently, especially with Las Vegas, as you can imagine, we've got a very transient population coming in and out all the time. Sometimes people are here on vacation and their child might get removed, and it may be more appropriate to just handle it in their home state. That can trigger a conference between our jurisdiction and whatever the home state jurisdiction is, to make a determination as to which venue is the proper one for the case to go forward in. We also have to make a determination at or near that hearing that reasonable efforts were made to prevent the removal of the child. And then also that if the court is going to remain involved in the case, we would exercise our emergency jurisdiction at that point and have to make a finding that it is contrary to the child's welfare to be returned to a parent at that time. If we make all of those findings, that triggers formal involvement with the court and the state. And then the state is required to file a petition within 10 days of that hearing, so that the parents know exactly what they're being accused of and so that they can answer to it with either an admission or a denial, which triggers further hearings in different jurisdiction questions.
That's I didn't know. It sounds like I mean, we barely even started, and it sounds like it's a pretty organized process.
And that's the most important hearing, really, of all of them. At start, if the judge who is hearing these cases has been adequately trained and knows what they're doing in dependency, that hearing is going to set the tone for the remainder of the case. Very often, the amount of information that I can draw out of a family at that point in time and obtain for the department, if they haven't been able to obtain it yet, will not only fashion how the department and the court will interact with that family, but you can really start working right at that point in time on trying to correct the safety issues that are affecting that child, so that you can decrease the impact that this whole thing has on the child's life. It really is about ensuring the parents' constitutional rights to parent their child, and ensuring that child's rights to be raised in their own home, if that's what they want, if that's where they want to be. We're really here to oversee and to interact with the state's actor, the Department of Family Services, to make sure that those rights are protected and that the right efforts being made to keep that family intact if we can do it.
Excellent. I guess we're going now into the adjudicatory hearing. Could you tell us about the significance of that particular type of hearing?
Yeah, now that one is definitely evidentiary in nature. With the preliminary protective hearing, sometimes you're still dealing with specific allegations. By the time you get to an adjudicatory hearing, the parents will, if that hearing is set, the parents will have denied the information in the petition, and the state has the burden to prove the allegations in their petition by a preponderance of evidence. It's a lower standard than other courts that are involved, and you would think, they're taking my kid away, it ought to be beyond a reasonable doubt. But because it involves child safety, it's almost a statutory error on the side of caution type of thing, where the judge is supposed to take a very close look at it. And if you're really going to impact people's parental rights, you want to make sure that you're doing it in the appropriate way. So preponderance of evidence is the standard. The state has a burden. They will try to convince the court that the state, the department, and the court need to be involved with the family for much longer than just the emergency jurisdiction allows for. And then the court makes a decision based on that. If the court finds the state doesn't meet their burden, then the child is ordered home to the parents.
How common would you say it is for parents to contest the allegations brought against them?
Very common at the start of a case. And as the time goes on, it becomes less common. It's like any other kind of litigation. As they start to be faced with the level of evidence that the state's been able to accumulate, their attorneys very often at that point are working with them to negotiate a resolution short of that evidentiary hearing. But I set a lot of trials every month, and I stack them very frequently, at least 2 or 3 deep, because they do tend to resolve on the day of trial. They'll come in, they will have been able to look at all the evidence, they'll know what the burden is, and may at that point realize that it would be better just get to work on getting their kids back than it would be to have the court find as true everything the state's been saying.
Okay, curious about the dispositional hearing. And I guess it's sort of a two-part here, as I'm also curious how often the state is found to have met its burden, but the court declines to exercise jurisdiction, and why something like that might occur.
Okay, so the dispositional hearing, just to explain what it is, that is the hearing where the court makes its formal pronouncement that it is taking formal jurisdiction of the child. It triggers some statutory review dates that are set up in 6-month intervals, to make sure that reasonable efforts are continuing to be made, and to follow up and help the parents where they struggle in complying with case plans and different things like that. At the dispositional hearing, there will be a report prepared and filed that should be available to the parties and their counsel at least 72 hours ahead of that hearing. There should also be a drafted proposed case plan that would be discussed at that hearing so that the parents are very clear as to what the conditions for returning their child to them is. Those are the things that are done at the dispositional hearing. Typically, the court does take jurisdiction at that time if we get to that point. However, as you pointed out, and I think I had mentioned in some of the informational posts I've been doing, is sometimes the court can substantiate the allegations of a petition after an evidentiary hearing, or even by plea, if the parents choose not to contest, find that yes, there was a circumstance where a child was being abused or neglected, but some time has passed by between the initial removal and the dispositional hearing, sometimes due to continuances and things with the actual adjudicatory hearing. We may be month, 2 months, 3 months into a case by the time we have that dispositional hearing. And so, though it's required at 45 days, you have to have good cause to have it move on further than that. But what'll happen is you get parents who, though they did make a mistake, neglected or abused their child, they realized, I need to fix something in my family here. And they proactively sought services, cooperated with the department, and brought things to a point that by the time you get to the dispositional hearing, they may have created a relative degree of the minimum safety that's required for the court not to be involved in their life. And if that's the case, the court doesn't need to take jurisdiction because you've reached your safety position. A dependency court is a court of limited jurisdiction. We are to get out of people's lives as soon as we safely and can do it. And that's those are the key determinations we're making all along the way. Is, does the department really still need to be involved with this family? Or has the danger now passed? Has the family constructed a safety plan that works in their home? Have they gathered around them resources and individuals who can help them maintain that child's safety? And if it reaches the comfort level that the court doesn't feel that further involvement is warranted, we may decline jurisdiction at that point. The other circumstance that will arise in is you will find, if the parties have, they don't do it a lot, but if they have beforehand actually had a court of general domestic jurisdiction involved that has made orders regarding custody, has made orders regarding issues that have come up between the parties before, and if they, based on their involvement with the department and the court, determined, you know what, my child isn't safe in my care right now, I need to give custody to the other party, or we need to increase the safety by adding a layer of supervision or anything like that, they certainly can stipulate to that. And if they've got an adequate governing order from the court of general jurisdiction, there's no need for the special jurisdiction of dependency to be involved. So that's another circumstance where I might decline jurisdiction. I might find that the domestic court has a good handle on this. They've got my findings from the adjudicatory hearing. They know what was going on with the family. It's not a situation where they can get another bite at the apple and try to rewrite the facts or anything. They have either stipulated or have some proceedings pending in front of one of our sister jurisdictions, and they're like, okay, we can handle it from here. Then my court doesn't need to take jurisdiction.
You know, I absolutely love that you mentioned that. I can't tell you how many messages that we get from people who think that the dependency court doesn't care because they didn't resolve all of these child custody issues. And it's important for people, I think, to know that the dependency court has a different objective in mind, what you mentioned earlier, which was to get, out as soon as possible. And it's very different from, it seems to me, it's very different from the role that a regular, child custody court or a judge presiding over the divorce with children has. And it seems like you made that distinction there, which I think is a really important distinction.
Yeah, it really is. If I might add, though, I'll tell you, I would love for all of my general jurisdiction colleagues to have an opportunity at some point to hear dependency cases, because in the dependency arena, you really do boil down what the best interest of the child actually means. It's kind of a general term that's in our statutes. And because of it, there's a level of subjectivity that might differ from court to court to court, officer to officer to officer. You have two people compare what they think are similar cases, and they got completely different decisions from different judges. And it's because of that subjective nature. But while I was hearing general jurisdiction cases and I was having people in front of me making best interest arguments, coming from the background that I did, where I was so focused, particularly on the safety aspect of best interest, I felt like it helped me make better decisions on custody. Because, you know, what is safe and is unsafe is, they're miles apart when you're in a general district jurisdiction court versus a dependency jurisdiction court. You could have a party arguing, you know, my child's not safe in this house because the refrigerator isn't working right now. Where the counterpart on the other side is, the child's not safe in the house because there's never been a refrigerator in the first place, and there's jagged things around that the kid can bump into, and there's stuff all over the floor. And so it gives you a perspective, and helps you, I think, guide parents who are not truly dealing with safety issues to try to put their differences aside in the best interests of their child and make things work. And so I found that I was really, I felt blessed that I had the dependency background when I started hearing general jurisdiction cases, because it gave a perspective that you just don't get anywhere else. And it made it easy to help litigants decrease their litigation, try to really manage the conflict between themselves, and realize all this fighting we're doing in domestic court is hurting our child almost as badly as if we were actually abusing or neglecting them. And when you get that perspective, you get way more child focused. It brings it right to a point for you where, instead of two parents bickering back and forth, you're sitting there going, this is what the child's seeing, this is what it's doing to the child. I need to help these parties realize that some things they are overinflating. But at the same time, you do have that danger background, so you can see the red flags. And if there is a domestic situation where there might be domestic violence, or there might be some kind of neglect or parental alienation going on, because of the work you've done on protecting kids day in and day out, you can spot some of the red flags and realize, yes, this is legitimately, that these parties have a legitimate concern that needs to be litigated right now, versus one that really should be settled.
Yeah. Some of our audience is actually attorneys and judges, and they've already seen a couple of the videos in your department. I actually want to mention that I got a few emails from judges who wanted to watch the Commission on Judicial Disciplines proceedings, and they just never had any time to go down and watch. So they appreciated the electronic coverage. They could go back and actually watch them. So I'm sure that maybe some of them will start to watch some of the proceedings, just because they can do so at their own convenience, because the judges are pretty busy, including yourself, I would assume.
Oh yeah, very busy, but I think we all could stand to learn from each other and some of the things that we're each experiencing. We have a pretty good group that way. We're all, particularly in family court, we are, for the most part, except for the newest departments, we're all in the same building and all on the same floor. And most of us have an open door to our colleagues. So, you have something come up, you stop in, you talk to another judge, you say, hey, this is the general circumstance I'm dealing with. Have you seen that before? And it can help. I find myself in that position a lot. People coming to me, especially if in a domestic case, the parties have raised an abuse or neglect issue, or have pointed out that the Department of Family Services has been involved with that family before. They'll come to me and some of my other dependency colleagues to help them interpret some of the records that are being put before them, so that they can, get a good idea of what it is that those investigative reports are really saying, and what some of the determinations the department's made internally really mean.
It's really heartening to hear that, because I kind of always wondered if the judges were, operating in silos, or if they kind of work together. And it's good to hear that there's some intercommunication and some camaraderie there between the different judges working together on these issues. So
we are all in it together, and most of us realize that. And so we do try to assist where we can. That's
great. So I guess the next question is the concept of the non-offending parent. I do get this brought up to me sometimes from the general public. Would you care to elaborate on that particular concept?
Yes, a non-offending parent is a parent that is, okay, there's a couple of ways to look at it. You can be non-offending in the instant matter. So say two parties have custody of a child in varying degrees, or a father hasn't established his rights formally, different things like that, and something happens. That thing that happened that put the child at risk, if it happened in the custody of one parent versus the other, the parent it didn't happen with is non-offending. They didn't do it. Okay. It doesn't mean that they didn't create the environment in which it could happen. It doesn't mean that they didn't have any knowledge that it was likely to happen. It means that they didn't do it. If though they come forward and they say, look, this child's before you because of something my ex did. I want my child. If they don't present a danger to the child, they absolutely have a constitutional right to have the child released to them right there. And that's a situation where the court does rely on the department to some degree in speaking to that person who is believed to be non-offending first, to gauge their protective capacities, to see if they knew what was going on, to see if they ignored it, to see if their own home circumstance is safe enough for the child to go home to, those kinds of things. And so the court will get reports on those parents, and if they are truly non-offending, if they don't pose any immediate danger to the child, then the court will release to them, and basically do a placement order under 432B.550 with a non-offending parent. And then that parent, the belief is that parent will go to the court of competent jurisdiction, the general jurisdiction court, and firm up their ability to protect the child by seeking either supervised visitation or sole custody or whatever they need to. If they don't have an intention to do that, or if there aren't other indicators that they can actually keep the child safe from the offending parent, then the court needs to remain involved and would rely on the state to make allegations regarding that party that are sufficient for the court to have jurisdiction over them. If the state does not, if the state just continues to treat them as non-offending and never gives us a line item in the petition as to why we should be enforcing our jurisdiction against that non-offending parent, we have to release to that parent. And so it's kind of a collaborative effort, really, very often at the time of the protective hearing, for the court to make some inquiries and to gauge how safe that other parent is. And if they're there and they're safe enough, that child's going home to them, and the general jurisdiction would be perfectly capable of further proceedings to keep the child protected.
I did not realize the significance of that question until you gave me the answer. I could think probably of another 4 or 5, but I'm going to stay focused. I'm going to stay on track. Really appreciate that response.
It is important though. There is case law out there, and this is how powerful being a non-offending parent can be. You can be a parent who didn't know you had the child. You can be a father, or mothers always know they had the kids. So that's why I'm saying father. It's not really a gender designation, but the father may have fathered a child and not known about it. And had he known, would have supported, would have had a relationship, would have done what he needed to do. There have been terminations of parental rights that have been set aside because somebody down the road did know who that dad was. They didn't take the time to notify that dad to make sure his due process was protected, and he could potentially come in and completely set aside the permanency planning and everything that the court had been gearing towards. And it has happened. So that's why those first hearings are so important to ask over and over again. Do we know who the parents are? Is there anyone that has a right to this child in some capacity that might be affected without due process by these proceedings? And so we're constantly trying to make sure that we front load that, because the most tragic things that happen are you get to the point where permanency is going to result in an adoption or something along that line. And then a party who wasn't noticed, who should have been noticed, who is truly non-offending, now comes forward and says, wait a minute, I have rights here. And that child may be completely geared up towards the permanency that you've been laying the groundwork for, sometimes for years. And so, and that could be really traumatic on the child. So then the court's got to really be careful how we introduce this individual to the child, how we help foster the relationship for that child in order to protect the constitutional rights of that individual. But at the same time, keep it from impacting the child in a more traumatic way.
And one of the big things for me that really jumped out was you used the word can in multiple, portions of that answer in really important areas where the non-offending parent can do certain things. And I can't tell you how many viewers are, or I guess people who send us messages are upset because the dependency court didn't just do everything for them. And it seems like for you, it's not just that the non-offending parent can protect the child, but will they? Will they? That's a big piece. I think that a lot of people don't understand is just because you didn't do anything wrong doesn't mean that answers all of the questions that a dependency court may have. They also need to know, as a non-offending parent, are you going to actually protect the child yourself or not? That just is not automatically assumed. So I really appreciate that portion going, you covering that portion.
Yeah, sometimes the biggest question you can ask is, where have you been? And why haven't you had a relationship up until now? Sometimes there's some really good excuses, as in, or justifications, as in, I didn't know where they were. I've been trying to find them for years. I've been actively frustrated in any effort that I've made to have a relationship with my child. Those are all things that should be confirmable facts. And it's not going to be just on bare allegations. Some non-offending parent comes forward 3 years down the road and doesn't, and all of a sudden frustrates everything. They've got to come in and be able to back up the position that they're taking. Absolutely. We're not going to be willy-nilly with the child's stability in that circumstance. We are going to do our due diligence, but there should, if that's true, there should be evidence, and it should be something you can obtain and show me. Where are the emails? Where are the letters? Where are the court filings? Where are those things? If you can provide me with that, you're going to get your fair shake. If you're just coming in here to frustrate my proceedings, the child's best interest is going to win out there, and I'm going to make the best decision I can for the child.
Thank you so much for taking that question. Really appreciate it. Next one, general sense, urgency of the proceedings, time limits, stuff like that. We may go into more specifics with the later questions, but I just was curious to hear from you how urgent is the court's attitude towards urgency and resolving these proceedings promptly.
Very, very urgent. They move fast, and there are reasons why. One, our statutes carve out specific timelines that don't necessarily comport with the rules of civil procedure. But then additionally, we have this overlaying federal level of guidance. There are federal guidelines that if they're not complied with by both the department and the court, the state risks losing funding that is key to keeping these families intact or making them safer. And so, the expedited nature of the proceedings, I mean, frankly, they have to be fast because you're interfering with parental rights. It's major. A termination of parental rights has been likened by courts to be the death penalty of civil matters. Now, there has been a lot of changes in the laws and things over the years that I don't know if it quite fits that description as much anymore, especially in a 432B proceeding. But it is still a drastic impact on someone's fundamental rights. And because of that, they deserve answers as quickly and as completely as we can give them to them. And so, like you're saying, that you're going to trial essentially. That's what an adjudicatory hearing is within 30 days of a petition being filed. You're making a determination as to formal jurisdiction in many cases within 45 days. You're taking a look at this case every 6 months, and the way that the statutes described, you really should, in an ideal situation, be achieving safe permanency for a child within 18 months of a case opening. So it's expedited. You keep it, it stays hot. You have to keep looking at it, and you have to keep asking the question, why is this child not home? Or why does this child not know what their future holds? This child needs predictable, safe permanency. So let's get it achieved. So yeah, we're moving quick. a lot of the time.
Yeah, I'm sure the viewers will appreciate to hear that, because that's another myth I think that you've just taken care of there. And from what I've seen of the statutes, you're right. Of course, I don't know as much because this is our first ever dependency proceeding we're covering, but it's encouraging to hear that. A little bit of a technical tangent here on the discovery process. How different is it considering how time sensitive the proceedings are?
Really, it is very different. By the time the department removes a child, they should have already been amassing a certain amount of evidence. By the time you get to that protective hearing, because their investigative requirements are ongoing, they have to continue to be investigating and assessing repeatedly. So they should be amassing case notes, relevant documents, photographs, other evidence. And so by the time we're getting ready, and because we have the adjudicatory hearing so quickly, really, and the district attorney's office has been very cooperative doing it. When an attorney for the parents makes their appearance, typically the state has already got a discovery package ready to go for them. Something that they can pick up right now, which is it's supposed to be everything they've got. And so you don't have the typical requests for admissions, requests for production, interrogatories, anything along that line. The state, because they have the burden and because they're affecting such a fundamental right, I have always taken the position from the bench that the state needs to be completely transparent and turning everything over right away as they've got it. On the defense side, it can be a little bit difficult to gather some of the information that you need to adequately protect the parents' rights. But at the same time, in order to do your duty to them as their counsel, you have to be proactive too. If you're going to be relying on witnesses outside the parents or documents that tend to belie what the state knows from their investigation, you've got to be providing that up front too. So there have been circumstances where we come to the day of trial, everybody is aware of a key document, it's out there, nobody's been able to obtain it yet. That's a good cause for a continuance. We want to make sure that our decisions are informed by real evidence, that they are reliable. And so any delay in the proceeding, I will typically take a very firm hand and let the parties know, look, you have this long to get that document to the other party. Do it and do it now, because we're going to go to trial on this date. And we will create on a case-by-case basis very, very frequently a briefing schedule if it's needed, or some guidelines as to how we expect the discovery to go forward. And usually it's do it right now. You're saying you have this document, get it to them. And let's make sure that the parents have the best defense available to them, and that the state is not blindsided or blindsiding the other parties. So it moves. We just kind of tailor them ourselves. There's been a push to try to get some specific rules of civil procedure carved out for these proceedings. We've got Rule 16, we've got 16.1, we've got 16.2. There's subdivisions there's subcategories that apply to the short trial programs, to criminal discovery, to civil, to family. We probably do. It would be nice to have it all in one place, but the statutes themselves, the spirit of the statutes is clear. This is an expedited proceeding. You need to get your evidence out right away. So we handle it case by case, right in the moment, a lot of the time.
Yeah, makes sense. Really, it really does. From my perspective, it makes a lot of sense. So typically, what is outlined in the reports and the proposed case plans that are submitted to the court?
Okay. Hopefully answers to all of the statutory questions. There are statutes that specifically detail what exactly has to be in each report. And so at a minimum, it should have that. A lot of it will be where the child's placed. Are they placed with siblings? If they aren't, why not? If they are placed with family, who is it they're placed with? What kind of visitation are the parents enjoying? What kind of progress have the parents been making on their case plan? What has the most recent assessment determined? Do you have right now satisfied conditions for return? If not, what's missing? There will be information about the child's educational needs, the child's mental and physical needs. There will be updates, hopefully, on who is regularly interacting with the child from a therapeutic standpoint, from a safety standpoint. We get reports from CASA. If they've been, typically those will speak to the best interest of the child. We get a number of supplemental reports that kind of just bring us right up to date. The original adjudicated allegations are almost always included, so that you're double checking and making sure that your planning does actually address an adjudicated allegation. Parents are not required to do additional services that there hasn't been an adjudicated basis for. So if they have a drug problem, they're not required to do domestic violence classes unless you have a finding that there's domestic violence in the home. Or if there's DV in the home, they're not required to do drug testing and drug classes if you've never provided the court with a jurisdictional basis to have them do that. So we're constantly comparing the case planning with what's been adjudicated. If new information comes up, which it does all the time, it may be, a parent they get 20 cases into a DV type oriented case plan where they've been getting domestic violence classes, and you find out, wait a minute, this person actually has a diagnosed mental health condition that affects their ability to keep their home safe. And if that comes up, or guess what, we just found out this person actually has a methamphetamine habit that nobody knew about, and that they were self-medicating with it, and that might lead to these violent outbursts. You find that out along the way and it wasn't previously adjudicated, there's one of two things that can happen. The state has to put it on in front of the court for adjudicatory evidentiary findings, or the parties need to stipulate to add it to their case planning. So there's got to be an evidentiary foundation for every way that we interfere with the family's life.
Excellent. So another really common question, probably one of the more important ones, is, are parents appointed a free attorney in these types of cases?
Yes, they are. That's one of the first questions that we ask at a preliminary protective hearing is, can you afford counsel? They are entitled to be represented by an attorney. If they can afford a lawyer, then they are told, go and hire one, or you represent yourself. If they can't afford, and all they really have to tell me is, no, I can't afford an attorney right now. There's all kinds of reasons why people can't come up with the retainer. And we have a panel of contracted attorneys who do a lot of work in this area, and we appoint a free attorney for those parents. And we do a lot with the Office of Appointed Counsel. We have a lot of interaction and dialogue with them to make sure that the attorneys that they're putting in front of us have been adequately trained, have adequate experience, and can handle this kind of a caseload. And so, I think there's a perception out there, and it always bothered me because my dad was a career public defender before he became a judge. And there's always this perception that the public defender is this free lawyer. They don't care about my case. I'm warehoused, and I'm one of 50 cases they're hearing, and that kind of thing. But it's really not the case. They're specialists. Though they can't legally call themselves specialists, they are specialists in what they do. They see it more frequently than anybody else. It's the same thing with our contract attorneys for dependency. These attorneys are day in and day out dealing with these issues, and very often are, to some degree, experts themselves in the area that they're practicing in. We do get private counsel coming in who are not in front of us as frequently, and you get a whole variety among private counsel. You have those that actually do have experience in dependency, or who are very good at learning something very quickly, and they come in and they do it, and they do it right. Sometimes though, somebody comes in, they've just, they walk in and don't realize what they got themselves into. The next thing you know, they're a little worried. And so in those circumstances, we try to identify what might be going on and steer them in the right direction as to who to talk to, so that they can bring themselves up to speed, so that we can ensure that parents are getting adequate representation, because they have a right to have adequate representation, and you're dealing with very serious issues. So I think if there's any concern from people as to taking a contract attorney versus going out and trying to hire somebody, our contract attorneys are very capable. They are they know what they're doing. They know the workers, they know the DAs that are involved. They are very much in the know as to how to represent someone in a case like this.
I got the same impression about the public defender's office during the 2020 election. Several of the candidates came on, and it was impressive to see just how much they did care, which definitely dispelled a myth for me. And now a bunch of them are judges now, considering the success of the public defender surge. So
yeah,
and I heard they had great investigators too. Pretty much everything consistent with what you just said. So I guess this is going to dovetail into the next question, which goes into the Child's Attorney Project and the role of the child's attorney in these cases.
Okay, the Children's Attorneys Project, often referred to as CAP, that's the abbreviation. They are an organization that's overseen by Nevada Legal Services, Barbara Buckley's organization. They are private attorneys who represent specifically the children in these cases. We appoint them to every case. And they only have so many attorneys, so we rely heavily on pro bono Children's Attorney Project attorneys. So they're constantly recruiting in the community, trying to get private attorneys to come in and advocate on a pro bono basis on behalf of the kids. Their practice model is to advocate for the child's wishes, the child's legal wishes in front of the court. Sometimes, based on their models, that requires them to substitute their judgment for the child's judgment, especially if the child is not verbal or too young, or somehow their capacity is limited and they're not verbal. In that situation, a Children's Attorneys Project lawyer who follows their particular practice model will, to some degree, substitute their own judgment. But for the most part, they really are there to advocate specifically for the child's wishes. And they represent them just like an attorney would represent a parent. The children are, as far as anyone is concerned, are parties to these actions. They are entitled to know what's going on in their life. You're making major decisions about that child's life. They should have representation, and they should have their voice being shared in the courtroom.
Yeah. And then I guess we can talk about the CASA program, CASA, I guess it stands for Court Appointed Special Advocate.
Yes.
And the role, as well as how often guardians ad litem are, because I think they're guardians ad litem, but correct me if I'm wrong.
Yes.
All right. Go into the details of the CASA program, everything.
Okay. Now, a CASA is not necessarily a lawyer, not usually a lawyer. They're a member of the public who is volunteering their service to get to know the child and to learn about the child's environment and to advocate for the child's best interest. We, by statute, are supposed to have a guardian ad litem appointed to every single child in the system. Right now, and they do their best, they recruit constantly at CASA to get people involved. We really only have a CASA for about a quarter of the kids that we have in our jurisdiction, just because of volume. We are a large jurisdiction. We, as opposed to other areas in the state, even including Reno, we have got far larger caseloads than anywhere else because our population is just so big. So we're constantly looking for CASAs who can come in, particularly for nonverbal kids. We are appointing CASAs because we would rather they, as a guardian ad litem, would be utilizing their judgment on behalf of the kids, so that the Children's Attorneys Project can focus on advocacy from an attorney standpoint. But the statutes require every kid to have a guardian ad litem. So it's been this constant battle for years and years and years, decades really, to get the public involved and to have them volunteer to be involved in these cases. But they do things like big brothers and big sisters do. They go out and they get to know the child. They interact with the child frequently. They put themselves in the shoes of the child and the environment the child is in, so that they can try to inform the court what that child's best interest is. Sometimes it diverges from what everybody else is saying is their best interest. It's just another safeguard that our statutes put in place to make sure the child's voice and the child's interests are paramount to the decisions that we're making.
One of the things that I like about from my participation in the program was that the CASA advocate is, at least appears to be, outside of the government, whereas the CAP attorney and the district attorney's office and the DCFS and the judge are all sort of part of the government. So you kind of get that outsider perspective.
And that other perspective is crucial. How can you make, I don't want to make decisions inside an echo chamber. I need to have the scrutiny of outside parties and that kind of thing, making sure that things are going right. Because a judge, though some of us act like we're all knowing, we are not. Our decisions are only as good as the information that's put before us. And so the more perspectives we can utilize in deciding what the legal truth of a matter is, the better. Because you're dealing with everybody, and you're dealing with differing perspectives, and everybody's version of the truth may be perceptively accurate, but it might not be objectively accurate. So bringing those things all together to find out what the best objective, truth is what a judge's job is.
Yeah. So two miscellaneous questions, and then we're pretty much done here. The first of the two is, are children entitled to be present at the hearings, and how often does it actually occur?
Okay. Yes, they are. Not often, but it's increasing. And that's one of the actual upsides to this pandemic situation we've been in this last year, is we have really relied heavily on alternative means of appearance at court. And the court has put a lot of money and effort and support into our Blue Jeans program working so that people can virtually appear. Children always have the right to be present in these proceedings, as any party would be. We hope that those that are advocating for them and those that are making decisions about their best interest will also consider what the impact of being in the courtroom is. There are varying schools of thought. Some people think they should be present for everything regardless. I'm not one of those. I like to leave the child's presence in court up to a combination of their lawyer and their CASA, particularly. Now, that being said, if the child still wants to be there, and even though everybody else thinks it's not a good idea, thanks to Blue Jeans, thanks to the opportunity of the court to be able to just clear the courtroom if needed, I want the kids there if they want to be there. My courtroom is decorated in a way to be friendly to children. I want them to feel comfortable there, but I'm super sensitive to the idea that I might traumatize them further. Just because sometimes I have to have very frank conversations with their parents. And sometimes in the course of visitation, the parents have created a picture for the child that does not reflect what's actually going on in court. And it can be extremely traumatic. It can bring all of the trauma the child has already experienced right back to the fore, and be a horrible experience for them. And so in trying to have a trauma-informed court, you're walking a line with when kids should be there and when they shouldn't. But I've always tried my best to accommodate a child appearance if they want to be there. And now with Blue Jeans, with the ability to segregate into a breakout session and different things like that, I think that I'm seeing more and more child appearances than I ever have before. As a side note, on the delinquency side, and I know it's a conversation for another day, there's a lot of feeling that children shouldn't be shackled when they're in a courtroom, and they shouldn't be made to feel like a criminal and different things like that. The ability to have them appearing electronically has given us the ability to make sure that they don't have to be shackled, to make sure that they are not in a holding cell or in a courtroom environment, that they're in surroundings that are supposed to be ideally being made as close to home as possible. And so it's been a real blessing on that side as well. And for parents on that side, a lot of parents work, and if they have to come to every single appearance for a child that's been getting in trouble, it can really frustrate everything that's going on in the family. Virtual appearances have really opened up, in my opinion, people's access to justice. And it's my position, and I believe it's shared by a lot, that at least a hybrid of virtual and in-person appearances is here to stay.
Yeah. I was monitoring the administrative docket in the Supreme Court, and there was a really good letter from Marshall Willick, I believe, submitted to the Supreme Court on what you just mentioned. Very eye-opening, and I also agree. saves a lot of time too. It's waiting around in the audience and getting, parking, going through. It just,
Oh, yeah.
it's really going to change everything, I think, and it's going to be fun to see just how different things are in 4, 5, 6 years.
Well, when you've got private counsel, you're getting charged for that wait time.
Exactly.
Sitting out there. Whereas now, I see a lot of multitasking going on, sometimes appropriately, sometimes not. We try to catch it when we can, but I think it's going to drive the cost of justice down for people. And it's also going to increase their access to quality counsel. If counsel can spend their time working on a number of things at the same time, I think that you'll have less people being turned away because you're just too busy.
Absolutely. Yeah.
I passed those kinds of cases along when I was in private practice. I'm like, no, this case is going to be a doozy and I cannot give it the attention that I need to. And I may have had to pass them along to somebody that's maybe not as capable as me, and where if it was affordable to them because they didn't have to pay for waiting around and they didn't have to come down all the time, they might have gotten better representation sometimes.
Yeah. Okay. Let's do the last question here. How often does the court monitor reasonable efforts by the Department of Family Services, and what can happen if the court makes a finding that a lack of reasonable efforts are being made?
Okay. That monitoring is ongoing, but by statute must happen at least every 6 months. There has to be a finding every 6 months at either the review or the permanency review that reasonable efforts have been made to reunify the family safely. So it's the key finding that's being made at those review hearings. So that's how often we're reviewing it. When we find that it has not been done, there's a number of things that can happen. And it can be devastating ultimately to the department if they're not doing their job. They rely heavily on federal funding. And if there is a finding in the record of a lack of reasonable efforts, and the federal government auditors find that out, they see it in their audit, they can retroactively pull all of the funding for that specific case all the way back to the beginning.
Wow. And
then the department would have to dig into its own budget to pay for what the federal government had given them funding for before. It's the finding the department never wants the judge making. And really, it's kind of interesting too. And I think it might be one thing that led to full district court judges hearing these instead of a combination of judges and masters. When it comes to these kinds of cases, as far as the ability of the court to penalize the government for abusing people's rights, it's really limited. The remedy is send the kid home. That might not be the right remedy sometimes. You might have a situation where the child really is in need of protection, but the department hasn't done their reasonable efforts that are required under the statute, and then you're in this spot. Sometimes I give them an opportunity to cure the problem. If I think it's going to impact the safety of the child, I will give the department an opportunity to cure that problem, but I will tell them specifically what I want done and what I'm going to consider as a reasonable effort. And I will set a hearing to have them come back and be accountable. But there are circumstances where you just have to make the finding, and they're just going to have to bite the bullet and swallow the pill and fund that case however it needs to be funded, because it really is one of our only sticks that we have for the government. Not a situation that they want to find themselves in, being called in on an or show cause regarding contempt. That's, and so they're going to pay attention to the reasonable efforts a lot more. But yeah, there are not a lot of remedies for a late filing of the petition. They don't file it within 10 days. Your only remedy is finding a lack of reasonable efforts. And that's not even necessarily the department. That might be the state. If they don't get a report in on time, different things like that. You don't want to overuse a finding of lack of reasonable efforts, because the consequence is funding that would have helped that family might now become unavailable when they really need it. And so what we'll try to do is see if there's a way to fix it before we have to actually make that finding. But sometimes it's just warranted and you have to do it. And so you do, because it's the only stick you have to motivate certain behavior that has to change. And so, yeah, we don't find it a lot, but I make a lack of reasonable efforts finding a few times a year. It does happen.
I really appreciate you coming on. I think the family division and the dependency court sometimes gets a bad rap. And I think one of the ways to heal is for judges like you to come on, communicate with the public, educate the public. I get a lot of feedback, so I feel that these types of videos are overwhelmingly positive and that they absolutely do make a difference. So I really appreciate you coming on, Judge Gibson, and I'm looking forward to doing more of this in the future.
Great. I will say, just in closing, some of those criticisms, they're warranted. They're out there for a reason. But since in the years that I've been part of this court, either as a hearing master or a judge, and particularly in the years of Judge Frank Sullivan, of Judge Diane Steele, judges that have come on with a mind towards changing the system. And as we've added Judge Giuliani, Judge Tootin, and now with the full cast of judges that we have all been spending years trying to get ourselves trained up and trying to make improvements to the system. And I can say, from my unique perspective on the bench in the last now 9, almost 10 years that I've been on the bench, we have made drastic improvements in child protective services, interaction with the public, and in the court's decision-making process. And there's always room for improvement, and we are always trying to improve, and there is still room to grow. But we really have made a lot of changes. And I think some of the old perceptions they die hard. They're slow to die. But I think that this kind of interaction with the public, more information being available to people, and and frankly, not having a fear of the public seeing what we're doing is the way to make those changes happen.
Yep.
We've got to be transparent. They've got to know what these cases are about, not only in this area, but in all the areas of law that we preside in. And I'm really grateful for the opportunity to interact with an informational organization that's going to get this stuff out to people that care and want to know about it.
Yeah, I completely agree. So yeah, thank you so much. I'm looking forward to our future interactions, and I hope you have a great weekend.
You too. Thank you.